Welcome to all. Let us recap what we have discussed in the previous class. In the previous class, we have discussed the few important definitions like the definition of claim and the definition of corporate person, who is considered to be corporate person we have discussed. Then we have discussed the definition of financial service provider, financial services. So the person who is providing the financial services is called as financial service provider. So that's why we have discussed the definition of financial services. Then we have discussed the definition of financial sector regulator, financial product, definition of financial product. Then we have discussed the definition of debt, where the debt includes financial debt as well as operational debt. So that's why we have discussed the definition of financial debt and operational debt also. Today we are going to discuss the definitions part. Another important definition is creditor under the Act, which is defined under section 3, subsection 10 of the IBC. Creditor means any person to whom a debt is owed and includes a financial creditor and operational creditor, a secured creditor, an unsecured creditor, and decree holder. So who is included in the definition of creditor? So creditor includes any person to whom debt is owed. So here any person who is entitled to receive money from the corporate debtor is called as creditor. So which includes various categories of creditors. Maybe financial creditor, operational creditor, he may be a secured creditor, or he may be unsecured creditor. Sometimes it is possible. Imagine I have entered into a contract with a company and I supplied some goods. Company is liable to pay the money to me, and there is a failure is there to pay the money. I went to the court of law. Court of law gave the judgment in my favor. Then I am called as decree holder. So here I am entitled to receive the money from the company. So any person who is entitled to receive the money from the company is called as creditor. So creditor means any person to whom debt is owed and includes financial creditor, operational creditor, secured creditor, and unsecured creditor, decree holder. So these are all the various categories of creditors. The next definition is corporate debtor, who is called as corporate debtor. Corporate debtor means a corporate person who owes a debt to any person. So in yesterday's class, we have discussed what is the meaning of corporate person already. Corporate person includes company or registered under the Companies Act, company registered under specific legislation by separate enactment, or any body corporate. These are all the various categories of companies already we have discussed. Okay, so these are all considered to be corporate person. So corporate debtor means a corporate person who owes a debt to any person. And the next definition, important definition, financial creditor. So already we have discussed that. Creditor means creditor includes financial creditor. In the previous slide we have discussed creditor includes financial creditor. Now let us discuss who is a financial creditor. So financial creditor means section 5 subsection 7, which is there in the part 2. Section 5 subsection 7 defines the term financial creditor. Financial creditor means any person to whom a financial debt is owed and includes a person to whom such debt has been legally assigned to or transferred to. So financial creditor means any person who gave the money to the company as a finance and to who is entitled to receive the money. So any person who gave loan to the company, that is financial debt, who gave financial debt to the company. And suppose take the example, I am the financial creditor. I have assigned my right to other person. Assignment means right to receive the money. Whenever I am transferring right to receive the money to other person, such transaction is called as assignment. So if I am assigning my right to receive the money to other person, then such other person is called as financial creditor. So that means any person who gave loan to the company or any person who is entitled to receive the money, if he is transferring his right to other person, that is assigning his right to other person, he is called as financial creditor. And another important definition is person, who is called as person. Person includes, we are having various categories of persons are there under the Act. Person includes an individual, natural person, and Hindu undivided family, HUF, a company. Company means, as already we have discussed, company as incorporated under the Companies Act, a trust and a partnership firm, limited liability partnership firm, or any other entity established under a statute. So if any other entity is established under a statute and includes person resident outside India. So even this word is also very, very important. Why? Because here the word person includes not only the person resident in India and also person resident outside India. So it means the person resident outside India is also having a right under this legislation. Okay. Then other definition, property. Section 3, subsection 27 of the Act defines the term property. Property includes money, goods, actionable claims, land, and every description of property situated in India, any property which is situated in India or outside India, every description of interest including present, future or vested or contingent interest arising out of or incidental to the property. So this is the definition of property. So if you observe the definition of property, which is very wider in nature, the meaning is very wider, is very broader definition. So property includes money. So money means what is legal tender of money. Okay, so anything which is legally accepted, that is called as money. Goods. So if you want to know the definition of goods, you have to refer the definition given under the Sale of Goods Act, Section 2, Subsection 7 of the Sale of Goods Act. Section 2, Subsection 7 of the Sale of Goods Act says that goods includes all kinds of movable property other than the actionable claims, and which includes grass or anything which is forming part of the land which is agreed to be severable. Okay, so any movable property where you are having commercial value which can be separated from the land, even if it is included in the land. Suppose take the example of coal that is there in the land actually, so which cannot be separated. Normally it is a immovable property. But if you are having an agreement to separate it from the land to sell iron or anything, then in such cases such core, such iron ore or coal becomes a goods. Okay, so anything which can be sold. Then actionable claim, where you can bring an action before the court of law and you can recover the money. Okay, and land and every description of the property. So property can have various names. Okay, so every description of the property situated in India and outside India. So here please remember the property may be situated in India or outside India. So why they are defining the property definition here? Suppose if the company went into CRP process, possibility is there the company may have property in India or property outside India also. So when you are forming the liquidation estate, when the liquidator is appointed, when you are doing the liquidation estate, in the liquidation estate you are going to consider all this property whether situated in India or outside India, because everything is an asset, and every description of the interest including present, future or vested or contingent. So there are various categories of interest. Maybe presently you are having an interest in one particular property, or in the near future you are going to have maybe contingent. So if any interest that you are going to arrive depending on one contingency. Okay, so all these things are considered to be property. Now let us see. So there are few judgments are there. What is the meaning of property? Property includes all licenses, permission of corporate debtor. Let me give you one example. One company is there, maybe private company, which is having license to do the wine business. Then that license is considered to be property. Maybe one company is having license to do the mining activities. So such license is called as property. Okay. So spectrum license given to corporator would be an asset. Why? Because when I am having spectrum, obviously it is which is an asset in the case of company. So spectrum license to corporator would be an asset because it increases the value of the company. It was held in the case of Union of India versus Vijay Kumar V. Iyer by the NCLAT. NCLAT held that spectrum license given to corporator would be an asset, so which will form part of the liquidation estate. And the Supreme Court in the case of Victory Iron Works Limited versus Jitendra Lohia held that asset includes property, even leasehold rights held by the CD. CD means corporate debtor here. So leasehold rights held by corporate debtor constitutes assets of the CD. So if you are having any leasehold rights, maybe I am having one lease, I am having right to have the possession over the land or right to have possession over the building. So such right is called as my asset. Okay. Information memorandum. Section 5, subsection 10 defines the term information memorandum. Information memorandum means memorandum prepared by resolution professional under section 29 subsection 1. So please remember, in the subsequent lessons we are going to discuss what is this information memorandum. Separate one lesson is dedicated for information memorandum, the contents of the information memorandum. Let me tell you briefly, when resolution professional is appointed, when the CRP process is going on, when the resolution professional is appointed, he is going to prepare the information memorandum. This information memorandum will be published and any resolution applicant can read the information memorandum. It's like information about the company, its assets, its liabilities, recent profits, every data, everything relating to the company will be there in the information memorandum. Okay, and recently NCLAT gave the judgment stating that information memorandum should consist or should contain the details about carry forward of losses also. So that means you should specifically state how much carry forward of losses are there in your company. So are you carrying forward the losses? Everything you have to give the information. Okay. So based on the information, the resolution applicant will read the information. Accordingly, he'll give the quotations. Okay. So that is the significance of information memorandum. Anyway, in the subsequent lessons, we are going to discuss in detail about the contents of the information memorandum. Okay. So next definition, initiation date. What is this initiation date? Section 5, subsection 11. Initiation date means the date on which a financial creditor, corporate applicant or operational creditor, as the case may be, makes an application to the adjudicating authority for initiating corporate insolvency resolution process or PPIRP, pre-packaged insolvency resolution process, as the case may be. So what is this initiation date? First of all, let me give you a brief introduction. Who can initiate the proceedings under IBC? In the subsequent lessons, again we are going to discuss in detail based on the sections. But under IBC, the insolvency proceedings can be initiated by three categories of people, three categories of persons. First one, financial creditor, and operational creditor, and corporate debtor itself. Okay. So we will discuss about the terms and conditions subsequently. So when you are filing an application to the adjudicating authority, please remember adjudicating authority means NCLT here. So before the adjudicating authority, before NCLT, when you are filing an application for CRP process, so the date when you are filing, that date is called as initiation date. Why? Because from the initiation date only everything will be started. Okay. Next definition, next important definition, insolvency commencement date. Section 5, subsection 12. This is also another important date that you have to remember. Insolvency commencement date. Insolvency commencement date means the date of admission of the application for initiating corporate insolvency resolution process by the adjudicating authority under section 7, section 9, section 10. So as already we have discussed, the CRP process, the insolvency process can be started by either financial creditor, operational creditor, and corporate debtor. So when they are initiating, that means when they are filing an application, there are certain points are there to be considered by the adjudicating authority. Checklist is there. The adjudicating authority will verify whether everything is satisfied or not. We are going to discuss subsequently the factors to be considered by the adjudicating authority while allowing the application under this act. Okay. So once the adjudicating authority admits the application, from that date onwards, insolvency commencement date. Okay, from that date onwards, insolvency is commenced. So why it is so important? Because we are having time limitations within 180 days. Like that, we are having time limitations are there under the IBC, Insolvency Bankruptcy Code. So all these things will start from the insolvency commencement date. Generally, it is called as T. So from T onwards, T plus 20, T plus 7, like that. Okay, so that is why from this date onwards, okay, when adjudicating authority admits the petition, application made by the maybe financial creditor, FC, OC or CD. OC means operational creditor, CD means corporate debtor. Okay, so if any application is made by the FC, OC, D, or CD, then adjudicating authority, after verifying the documents, he is going to admit it. Okay, so once it is admitted, then once it is accepted, the application, then from that date is called as insolvency commencement date. Suppose if I am selling some goods, or if I am rendering some services, obviously I am supposed to receive some money. So the creditor in this case is called as operational creditor. So operational creditor means to whom operational debt is owed as a day-to-day activities. Okay, so whenever I am doing day-to-day activities, as a part of day-to-day activity, maybe sales, maybe rendering of the services, as a part of day-to-day activities. Okay, so if any liability arises, then such liability is called as operational debt. So who is included? Operational creditor means a person to whom operational debt is owed and includes any person to whom such debt has been legally assigned. Suppose, take the example, I have delivered some goods to some company. Obviously, here in this case, I am considered to be operational creditor. I have assigned this right to someone else. Then, even such person is also called as operational creditor. Next definition, financial institution. Section 3, subsection 14. Financial institution means a scheduled bank. Financial institution as defined in section 45I of RBA Act, Reserve Bank of India Act 1934, and public financial institution as defined in clause 72 of section 2 of Companies Act 2013. And such other institution as the central government may by notification specify as a financial institution. So financial institution means prima facie it's a commercial bank, it's a bank, scheduled bank or any financial institution as defined under the RBI Act, or public financial institution, because we are having various categories of institution, public financial institution, scheduled commercial banks, NBFC. So these are all the various categories of the institutions which are considered to be financial institutions. Next definition, dispute. This is very important definition. Dispute is defined under section 5, subsection 6. Dispute includes a suit or arbitration proceedings. So dispute can be a suit. Suit means whenever you are filing a case, so that is called as suit, or arbitration proceedings relating to the existence of the amount of debt. So the arbitration proceedings or suit can be related to existence. So someone may argue that I am not liable to pay. So other person may argue that you are liable to pay. So there is a dispute as to the existence. So the existence of the amount itself is in question. Okay. Or else the quality of the goods. The dispute can be related to quality of the goods or services, or breach of a representation or warranty. Maybe while doing the sales, generally puffing statements will be there. Majority of the cases, the seller may give so many puffing statements. Okay. So if there is any statement which is in the nature of warranty, okay, whenever there is a breach of representation or warranty is there, then obviously opposite person will have a right over the other person. Okay, so whenever there is any suit is there or arbitration proceedings are there related to these things, then that is called as dispute. So whether pendency of criminal proceedings, will it amounts to dispute or not? In the case of Totappa Nainar Muhammad Sirazdeen versus Intex Technologies India Limited, NCLAT held that pendency of criminal proceedings did not constitute pre-existing dispute. Why? Because under the IBC, within the ambit of dispute, we are going to include only civil dispute. We don't include the criminal proceedings because criminal proceedings are totally different. Okay, so that's why if any criminal proceedings are pending, then such criminal proceedings cannot be considered to be dispute. Okay. Then mere filing of application. So under MSME Act, there is a provision for filing a application for reference under section 17 and 18 of the MSME Act. So when any MSME files an application for reference under section 17 or 18, then such application is not considered to be dispute. Okay. Then NCLT in the case of, it was held in the case of I Value Advisors Private Limited versus Srinagar Banihal Expressway Limited. In this case, the NCLAT held that mere filing of an application for reference under MSME Act is not considered to be dispute under IBC. Next. Suppose there are proceedings are there against one company under section 138 of the Negotiable Instruments Act. So section 138 of Negotiable Instruments Act deals with the dishonor of the checks or check bonds cases. Okay. So if any proceedings are there, then will it amounts to pre-existing dispute or not? Yes, it amounts to pre-existing dispute. It was held by NCLAT in the case of AD Electro Steel Company Private Limited versus Anil Steels. In this case, it was held that when any case is pending before the court of law under section 138 of a Negotiable Instrument Act, such proceedings are considered to be pre-existing dispute. Okay. Suppose if any civil suits are pending, then in such cases, will it be considered to be pre-existing dispute? Yes. Pendency of civil suit for recovery of money is considered to be pre-existing dispute within the meaning of IBC. It was held by the NCLAT in a landmark judgment, Landmark Reality versus Siroya Developers Private Limited. So in this case, it was held that if any civil suit is pending before the civil court for recovery of the money, such suit is considered to be pre-existing dispute. Then, secured creditor. Who is a secured creditor? Secured creditor means a creditor in favor of whom security interest is created. So any person who is having security interest over the assets of the company, he is considered to be secured creditor. Then, what is security interest? We should understand what is security interest. Section 3, subsection 31 defines the term security interest. Security interest means right, title or interest or a claim to the property. So, I may have a right over the property, some right. I may have a title, that is ownership, or I may have some interest, or I may have some claims over the property. So, created in favor of or provided for a secured creditor by a transaction which secures payment or performance of an obligation and includes mortgage, charge, hypothecation, assignment, and encumbrance or any other agreement or arrangement securing payment or performance of any obligation of any person. In a simple language, suppose I am giving loan to someone. I am giving loan to a company. The company is creating a charge on the assets on its assets in my favor. Then I am considered to be having the security interest. So whenever I am having any right or any title or interest on any property, maybe the right may be created in the form of a mortgage, that is movable property, or charge, or hypothecation, or assignment. Okay, so whatever may be the mode that you are creating, but I am having a right over the property. Okay, in such cases, I am considered to be having the security interest. So provided that security interest shall not include performance guarantee. Okay, suppose when I am giving performance guarantee in favor of other persons, stating that so and so person will perform properly. If he fails to perform, then I am going to compensate you. Okay, I am going to pay the compensation. In such cases, that is called as performance guarantee. Okay, so performance guarantee is not included within the meaning of security. In today's lesson, we have discussed few important definitions like definition of creditor and the definition of corporate debtor, definition of financial creditor, and the definition of person. So who is considered to be person, we have discussed. Then we have discussed the definition of corporate debtor, who is a person who can file an application under IBC. Financial creditor, he is one of the person who can file an application under IBC. Then we have discussed the definition of property, another important definition. Then we have discussed the insolvency commencement date. What is considered to be insolvency commencement date? In the subsequent lessons, we are going to discuss about the timelines, where the timelines are calculated from the insolvency commencement date. Then we have discussed about the definition of dispute and the definition of secured creditor and security interest. Thank you.